You ever been involved in an auto accident? Not sure how the claim was going to be handled or how to proceed with it? Well, join us today on Health and Information. We're going to go through the pathway of settling a personal injury claim.
Where were you when the lights went out? Who did you call and when you gave them a shout? Did they pick up the phone? Did you get a machine or some front office drone? You know what I mean. You want to talk to somebody who knows what they're talking about. So call Marie now. Electricians with a mission will get you connected. We're Marie Electric.
Hi, this is Larry Murray with Murray Electric. We appreciate your business and we don't take you for granted. While nobody likes to have electrical problems, we want you to know that we will be here for you when you do need an electrician. And remember, you don't get phone shuffle when you call Murray Electric, because we have a real live electrician that answers the telephone. Remember, if you're in a hurry, call Murray, 918-835-9605. 918-835-9605.
We'll get you connected. We're Marie Electric.
An accident can turn your life upside down. Immediately, you may face problems like who will treat your injuries? How will your car get fixed? What are you going to drive in the meantime? You need solutions now. At Benedict Law Office, the care you deserve can begin at your own home. No office visit is necessary, and you pay no fee if there's no recovery.
At Benedict Law Office, there are no problems, only solutions.
Call Benedict Law Office for your free consultation today.
Hi, I'm Dr. James Bissland. Welcome to Health and Information. This is for June of 2014. Today we're going to have a program to help you understand what happens when you are involved in an auto accident from the very beginning all the way through negotiation with the liability company, as well as the settlement and disbursements. When you first have an auto accident, the first thing that everybody would tell you to do is get your medical taken care of. So we're going to assume you've already done that, and now it's time for you to figure out how are you going to handle dealing with the insurance company. Now, most people who come into our office, we recommend that they hire an experienced personal injury attorney who can help them to wade through all of the insurance companies, the adjusters, the information. The insurance companies have professionals who work for them, look out for their best interests, and most people are not capable of providing that for themselves, and so we recommend that they hire an attorney. Joining us today is our resident health and information attorney, the guy that we turn to for answers to our questions. And I'd like to introduce you all again to Lloyd Benedict from the Benedict Law Office. Lloyd, welcome to the program.
Thank you, Dr. Bissland. It's always an honor.
And we appreciate you and your staff taking the time today to help us go through this pathway so people have a better understanding of exactly what it is that happens. A lot of times when I tell people, they recommend that they have an attorney, the one thing that they're concerned about is that it costs too much to have an attorney, and they don't know whether the attorney's office does enough to warrant that. So I thought we would let your office and your staff, as well as yourself, go through and show everybody, show our patients and our viewers what it is that it takes to take a personal injury claim from the beginning all the way through settlement.
Sure. This will be a great, unique opportunity to get a little sneak preview of what happens inside the a law firm that handles cases, and I think this will be a good experience for people to truly understand that when a lawyer does the work on it, what's happening behind the scenes, what you don't see, what you don't hear, or you say, "What's that lawyer of mine doing out there?" This will give them a better idea what's happening.
Exactly. So we're going to start off with looking at it as he does an intake. So he's going to tell us now what we do with a new client that comes into his office here, or Lloyd or one of his employees will come meet you at the clinic, your home, your hospital, wherever you happen to be, and help you begin the process. So I'm going to turn it over to Lloyd and let him pretty much talk through how he handles the initial intake.
Thank you, Doc. The Benedict Law Office, obviously, we deal with personal injury cases, and we're dealing with people that are injured. Some people can come to the office. Some people cannot come to the office. So we're always willing to accommodate their needs. For example, we come out to Dr. Bissland's clinic and sit down and meet with folks, and have done that, and that works out real well. That way they don't have to drive all over town. They're injured. Their car may be damaged. There may be a whole slew of problems that may require us to more conveniently come out and accommodate the injured person. A lot of times on the more serious cases where there's been some catastrophic injuries, I've met in hospital rooms, or I've met here in my conference room. This conference room here gets a lot of activity regarding intake. And the intake process really is the beginning. It's where what lawyers do is we look for problems, and if we can anticipate what the problem is going to be of a case and come up with a solution along the way, that's going to avoid problems in the future, because the insurance companies use those problems against the injured victim. For example, one of the more common ones, it might be a minor impact to the car. It might be $300, $400, $500, $600 worth of damage. Anything under $1,000, the insurance company already has booked as being a mild impact, and are going to be very defensive on that. Well, we know it's all true that you can still be injured at low velocity accidents, but the insurance company, even though they know that as well, they also know juries don't really understand that. And so there are ways that we can develop a case, build the case up, and make an argument to the insurance company that lets them know that if we can't get the case settled, it can move on to court, and it'll have a foundation of evidence to make it a little bit stronger argument. But that being said, there are literally hundreds of defenses that insurance companies can use, and a lot of them have to do with the fault of the accident. A lot of them have to do with the type of injuries, pre-existing conditions, subsequent injuries, gaps in care, overutilization of care, inconsistent evidence with what a person is saying. That, for example, a person might say that they're hurt, they're injured, they've been debilitated due to the injuries, but yet they've never missed a day of work. And so these things don't make sense to the insurance company. So when we sit down and do an intake, we're looking for all the things, the history of what happened in the case before then, and then we're going to develop a legal strategy beyond that. A lot of it's just name, rank, serial number, addresses, who you treated with, what for, those basic informations that we usually get in the intake. But this is the basis for the legal strategy right here.
Now, when you're talking to somebody for the first time, you want to get, of course, all their personal information, the way the accident happened. At that point, do you also give them any specific things that they can do to help you?
Absolutely. There's, in fact, all my clients get a new case client package. This is something that I've tailored over the last 25 years to help a person understand what I need along the way. We don't have a crystal ball, so we rely upon our clients to inform us if they go see a new physician, or if they've gone back to the emergency room, or if somebody is calling them regarding the case. And so it requires a lot of communication to us, a lot of input to us. Likewise, requires a lot of us taking that information and filtering it and then getting back to the client to say, here's what you're going to do with that. For example, some of the initial stuff is their car damage. They may need a rental car. Or there may be an evaluation on a total loss for their vehicle. So we get into it and analyze the value of the cars, and we'll actually get back with the insurance company and engage in negotiations on the car damage. We don't charge for that. That's a free service at Benedict Law Office. whether it be a repaired vehicle or a total loss vehicle, or get them to a rental car, or negotiating with Story of Record to get the car out of there, whatever the case may be. We understand that's the biggest stress they're dealing with, but that's some of the information that we're providing them up front. Then we move into the things that are the real, what I call the golden BBs of the case. Where are they going to be looking at? What are they going to be the problems? That's what an insurance company does. They look and have a playbook, and they go down this playbook, and they try to get the case to conform to something that's going to fall apart where they can take control. That's why a lot of people will mess their own case up inadvertently, because they'll cooperate with the insurance company when there's no duty to cooperate with them. Giving them information. There's no duty on the injured victim to give them that information. People have this misconception. They believe that if they cooperate with the insurance company, the outcome of the case is going to be okay and they won't need a lawyer and so forth. In reality, they're being led down a primrose path of destruction. They have no idea that the insurance company is going to drop a bomb on them at the end.
Well, it's like I said earlier, they have professionals who are there to look after the insurance company's interest. They have no obligation to the patient at all, do they?
No. The only obligation they have is to their own insured. The person who usually caused the accident, their insurance company, it is their duty, contractual duty, to protect that person that caused the accident. You'll know a person's in trouble when you have a patient come in and say, well, I was talking to my adjuster over at that insurance company. Well, one, it's not your adjuster. It's the other person who caused the accident's adjuster. That person that you're dealing with is a hired gun for the insurance company to pay you as little as possible, if anything at all.
That's their job.
That's their job. That's how they get $1 billion profits every year and have these large companies and TV campaigns that are millions and millions of dollars a year. That's what they do. It's a money vacuum. We're required by law to buy insurance. It's kind of legalized extortion. We have to buy insurance, pay premiums to these people, but there's no law that says they have to pay anything out. They do that because they do it to make a business decision. A settlement ultimately is something that happens because of the evidence persuades the insurance company to go ahead and compromise the case, as opposed to the injured victim filing suit in court, which brings me to the next premise. You really hire a lawyer to stay out of court, not to go to court. And I think people have a misconception about that.
But you always prepare from day one as if you are going to be in court.
Yep. Don't have to go to court if the case has been prepared to go to court. If the insurance company sees that up front, they see the evidence laid out, it makes sense to them. All the weaknesses of the case have some type of response, some type of answer, some type of strength to make an argument as to why. For example, a common weakness is people may delay going to a doctor 2 weeks. Insurance companies utilize that in their favor to say, well, I guess you're not that hurt if you took 2 weeks to go to the doctor, or something other could have happened other than this accident here. Maybe you fell down some stairs 3 days later. How do we know it's from the accident? There's no chain of evidence that starts from the day of the accident. For example, a better situation is an accident. Paramedics show up, there's an ambulance ride to the ER, and then they follow up with Dr. Bissland's clinic. All right, that is something you show a chain of evidence that the causation's there. Whereas there's an accident, the people swap information, no police are called to the scene. Later on, the defendant who caused the accident may change his version of the facts. It may have sounded like he was accepting fault at the scene, but later on, well, that car was coming on too fast and I pulled away from the stop sign. And they kind of change things. Well, that insurance company will pick up on that. And then if there's a delay going to the doctor, it just causes problems. And that's what we have to look at during the intake process is, all right, well, we know it's going to be a problem. That's why I tell people when they try to handle their own case, then they come to me 2, 3, 4 months down the road, and they go, gosh, I wish I knew it was going to be a problem. Otherwise, I would have came to you right up front. Well, it's always going to be a problem.
You need to plan that it's always going to be.
Yeah, it's always going to be a problem.
And the longer the person waits after an accident till they begin medical care, the tougher that makes it also to settle.
From a legal standpoint, from an evidentiary standpoint, that's just something that's some other issue that we have to address and come up with a solution for, not to mention that they're not doing themselves any good from a health standpoint as well.
Absolutely true. Okay, so now you're meeting with the client. What is other than the personal information, how the accident happened, what else do you need to have from them, and what other instructions would you give them that what they need to do for you to help you?
When we meet with a client for the first time, obviously getting basic information is going to be helpful. A copy of their own insurance policy, photographs of the damage to their car, at least a mental list or a written list of all the medical providers that they've seen or are scheduled to be seen, copies of all their prescriptions. These are all just the starting points of the case itself. You'd be surprised how many people come in and don't even know the name of the insurance company who is responsible, or do not know what a claim number is, or they've been in contact with them for 3 or 4 months and they just absolutely have no information who they've been talking to. So that's critical that they have that information in front. If they don't have it during intake, I can always come back and get it. Maybe they didn't bring the papers with them, and so we'll do a follow-up and get that information. Health insurance, are they going to use their health insurance? Have they used their health insurance? Are they on Medicare? Are they on Medicaid? Those are things that are very relevant, because obviously that comes into play later on if there's a settlement. Certain people may have the right to get reimbursed back, so these are things that we need to know up front. For example, if your health insurance pays for your emergency room and you turned into Blue Cross Blue Shield, they paid. By contract, Blue Cross Blue Shield has the right to get reimbursed back. Well, that's something that we need to know up front, because if and when the time gets to the point we settle the case, we have to have an accounting of where all the monies go from the settlement, and to medical providers and to health insurers and Medicare and Medicaid. Those are things that are very important for us to be able to finalize the case should we get to a settlement point.
Okay. Now, when it comes to, you said you get a copy of the patient's insurance card, and it comes to their own insurance. Some people have MedPay, some people don't have MedPay. I have a lot of people who are not wanting to use it because they're afraid that if they use their own MedPay, their premiums are going to raise. We understand that does not happen. Is that correct?
Yeah, that's correct. That's correct. In fact, there's a state statute that says that the only way that a person's insurance policy can ever be reevaluated, to be raised or canceled or non-renewed, is due to a fault situation where they've caused an accident, or where they have received citations from the police, or they change from the risk of a vehicle, going from like a Volkswagen to a Corvette, would change the premiums. The fact that you make a claim for medical payment coverage is a no-fault circumstance. In other words, MedPay is a coverage like health insurance built into your insurance policy. Some people have it, some people don't. It comes in different amounts. There may be $1,000 MedPay, maybe $2,000, maybe $10,000. I've seen $100,000 MedPay. Rare, but it's there. And when you make a claim for it, if you look under your policy, it says that they'll reimburse for medical bills up to the limit of what you're covered for, whatever you selected to purchase, if you've purchased it. Not everybody has MedPay, but if you purchase it. And it'll pay for reasonable and necessary medical treatment. So obviously, if you get a Band-Aid put in your hand and a doctor charges you $5,000 to put a Band-Aid on there, they're not going to give a check for $5,000. They're going to have it evaluated to look to see it's consistent with the injuries, the nature and extent. Then it's turned into my client's own insurance, and they'll actually issue a check, reimburse back for that bill. Maybe sent directly to the doctor, or it may be sent to my patient, or it may be sent to my office. If it is liened, it's typically sent to the doctor's office.
Okay. All right. So now you're done your intake. You've got all the information you need. Let's say you meet the client either at their home or in the hospital or in the clinic. Then you bring all the information back to your office, correct?
Correct.
And then now, if you do the intake, or if you have one of your other employees do it, they pass that off to somebody. Is that correct?
Yeah. From this point, after the intake's all compiled, we have all the general information that we need, or the client has a list of things that they've been informed to provide us. As I mentioned before, we give the clients all this, it's just a new client case packet. Really, it's got a what we need sheet. We need a copy of the policies, pictures, photographs, prescriptions, any letter that gets mailed to them, any change in physicians, and we go over these things right here. Some of these items on this list don't happen or have not happened yet, but will happen in the future. So we want to make sure they have an understanding that we need this stuff in order to pursue the case. Once we have everything in place here, once they've been informed of that, then it goes to the next level. The next level is just basically, it's more of an administrative function. It's really setting up the file. Misty in my office sets the files up. She enters the client's name into a database. She'll actually punch holes in the paperwork and start setting up evidence on the right, correspondence on the left. It's the old traditional system I've used for 27 years now. And then we start getting letters out to the insurance company. They call them LORs, letters of representation. A letter of representation is where the insurance company's been put on notice that Benedict Law Office represents that victim, that client, and one, don't talk to my client, don't communicate with them. Then we ask them to provide information. What's happened on the claim at that point? I need copies of any recorded statements they've taken from my clients. I need any kind of photographs that they've taken. I need the amounts of coverage that their insured has. Do they provide this? Sometimes they do.
Are they, excuse me, are they obligated to provide that?
They're not obligated to
They're
provide
not
it.
obligated,
Yeah.
okay.
So it's more of a spirit of cooperation. I will do certain things to help them out, evaluate the claim, if they do certain things to help me out to understand what's happened in the claim up to that point. That's when we get in, when that information comes back in, after Misty has it set up. Within 3, 4, 5 days, then we'll start getting the correspondence back from the insurance companies, and that's where we see how bad the little oops were that my clients made before representation. That's when we start seeing recorded statements where my client literally told an insurance company that they were not hurt 24 or 48 hours after the accident. That's when the statement was taken. And then they obviously, the symptoms start setting in. They start manifesting themselves 3, 4, 5 days later. But the insurance company has a statement that says, no, I wasn't hurt, Oh, maybe I got a little stiffness in my neck, but I'm not hurt. Well, next thing you know, now we're in a full-blown treatment plan, but we've already got a recorded statement. So that's where we start learning, okay, well, we know that's going to be a problem. How are we going to get around that? And that's when we start utilizing the legal experience to be able to make those arguments to counter those things.
And we as the provider can help you there by documenting when the symptoms began and how they began maybe 72 hours after an accident.
Right. Well, that's when the teamwork starts developing at that point right there, where it's the medical legal function of trying to help the patient, and then we're on the same page. You, the physician, trying to get their health taken care of. Me, the lawyer, trying to make sure that the person that's responsible for these injuries are going to be held accountable.
One of the things that patients will often tell me that after they've met with you or one of your employees is that they have been asked to keep a journal. Would you explain the journal? What is wanted on there? What do you want them to put in there? And what benefit that gives them?
Yeah, the journal is something that is going to be able to accommodate a few things. One, it is a diary of activities that they're having problems with. Pain and suffering is not ouch, I hurt. Pain and suffering is what you can't do because ouch, I hurt. So one of the best ways for me to understand a person's injuries is to have them journalize it when an activity comes up. For example, May 21st, I could not mow the grass. I could not do my garden. I could not pick up my laundry basket. We're not really looking as to the pain or the pain levels or the symptoms they had. We've got that in the medical records.
Exactly.
This will at least correspond with, where their activities are and how long it's going to take to return back to the level of activities that they enjoyed before the accident. That's what pain and suffering is, what you can't do or what you have problems doing. And so the journal is something that the patient can at least be able to recall 6 months down the road as to what problems they were having 6 months earlier.
They're not going to remember them otherwise.
They're not going to remember those little activities. And so that helps us, and it's a starting place. What's important about the journal is not so much that I need it specifically for the case, which I do, but I really like them to tell the physician. I like the patient come to you and say, hey, Dr. Bissland, when you ask them, all right, on a revisit, how are you doing today? How are you feeling today? And you look at your chart and you see that their pain levels were at 7 in the neck and a 6 in the back. Pain levels on 0 through 10, 10 being the worst pain they've had. And and they tell you, well, I'm still at I'm still at a 6 in my neck or still at a 7 in my back. Well, what does that mean? What does that 6 mean? We know that you utilize it to look at it to show whether improving or getting worse or whatever the case may be, among other things. The way the insurance company looks at that is it consistent with the injuries? So if I'm a pain level 8 in my neck and I'm that way for 3, 4, 5 weeks, but yet I've never missed a day of work. Yet I'm still doing my lawn mowing. I'm still lifting my child. I'm still doing all my household chores. I'm still taking vacations. Well, that doesn't make sense. And so that's something that I can see along the way if they have an activities journal, if they're putting in there, no, I'm 8 and I'm not mowing my grass, and I'm at 8 and I've got my daughter coming out helping me with the laundry, and I've got a babysitter now coming in to help me with the kids. We can now look at it from the standpoint that the activities that they're being missed and the injuries that they're complaining of are consistent. That will be one of the first areas the insurance company attacks it. So we look at it and we monitor those things, and we see that their lifestyle is not consistent with the symptomology on there. We know we're going to have a problem, and we usually call the client back in and say, "You're overdoing it. You know, if you're on medications, you're on painkillers and anti-inflammatories, and doing these activities that you shouldn't be doing, when the doctor has you limited on there, that's going to come back and bite you later on in the case." So again, that's why we use these journals, is to make sure that we understand where they are, and we know whether there's going to be an argument waiting for us at the end, or whether we have a stronger case because the client's being consistent with the activities and what they're reporting to the physicians.
Okay. We're going to take a break. We'll be back with more.
Are you in pain? Then meet the doctor. Neck pain, headaches? Meet the doctor. Low back and leg pain? Meet the doctor. Arm, shoulder, and hand pain? Carpal tunnel syndrome? Meet the doctor. Injured in an auto accident? Meet Dr. James Bissland at Bissland Chiropractic, where you can get your first visit free this month. Call Bissland Chiropractic at 838-4252. Bissland Chiropractic.
Where were you when the lights went out? Who did you call and when you gave them a shout? Did they pick up the phone? Did you get a machine or some front office drone? You know what I mean. You want to talk to somebody who knows what they're talking about. So call Marie now. Electricians with a mission will get you connected. We're Marie Electric.
Hi, this is Larry Murray with Murray Electric. We appreciate your business, and we don't take you for granted. While nobody likes to have electrical problems, we want you to know that we will be here for you when you do need an electrician. And remember, you don't get phone shuffle when you call Murray Electric, because we have a real live electrician that answers the telephone. Remember, if you're in a hurry, call Murray, 918-835-9605. 918-835-9605.
We'll get you connected. We're Murray Electric.
An accident can turn your life upside down. Immediately, you may face problems like who will treat your injuries? How will your car get fixed? What are you going to drive in the meantime? You need solutions now. At Benedict Law Office, the care you deserve can begin at your own home. No office visit is necessary, and you pay no fee if there's no recovery.
At Benedict Law Office, there are no problems, only solutions.
Call Benedict Law Office for your free consultation today.
Okay, welcome back to Health and Information. This is June for 2014, and I'm here with Attorney Lloyd Benedict, and we're going through the steps or the paths of settling a personal injury claim. Now, Lloyd, once you do your intake, either you or one of your employees, they bring it back to the office. You said you have Misty who puts all the information, puts the chart together, the file together for you, and then it goes where?
From that point there, then it's assigned. We have an alphabet system here. The A through L's will go to my legal assistant, Shelby. The M through Z's go to Stacy. We determine if there's multiple people in the car, we determine who the driver was. That's the alphabet.
I see. Okay. And then they take the file and what's their responsibility there?
From that point, of course, I may have missed a step on Misty. Misty also has contacted the insurance companies as well and given them the basic facts to get a claim number if that's not been done already.
Okay.
So sometimes there might be, it might sit on that front desk for about 2 or 3 days before it actually gets assigned out. And then some follow-up information that we're waiting for the clients to bring, some of the stuff that we discuss at intake. Once it goes to Shelby or Stacy, at that point there, they'll do what's called a new client follow-up. And that is more of a expanding on the intake information. Again, the intake, we want to do this really for purposes of just getting some basic information, developing that early legal strategy, but it gets more refined when it gets to their desk. And so there's going to be a follow-up phone call from Shelby or Stacy at that point to the new clients and say, okay, here's what the intake shows, or that didn't have this information at the intake at the time. Do you have that information now? So we're doing that, again, that initial build-up from that standpoint. That's when we get into the real nitty-gritty of some of these things, or that's when we start gathering the facts, doing the investigation, which is the first step of the case, is investigation. And
at this time, the patient's usually still treating.
The majority of them are still treating.
Right.
A handful of clients will come in already released from the physician, have had a bad experience with the insurance company, now wants to get a professional to argue their case for them, which those are what I call reactive cases, not proactive. When we get a case early in and it goes to those steps that we're talking about, we're being proactive to the problems of the case. Every case is a problem.
Exactly. And the more complications, the more problems.
Well, it's, that's what we are. We're problem resolution, and that's part of the investigation process. It could be one of different things that come up that we know right up front. There's going to be an argument, who had the red light, who had the green light. It's going to be something to, as I talked about before, the delays in treatment or the gaps in treatment, or some type of overutilization argument, or a pre-existing condition, or the client may have a credibility issue. So we're gathering this information and we're contacting witnesses, taking recorded statements ourselves, going to accident scenes, taking photographs. Google Earth really is a great tool now where it's kind of kept us from having to go to the field in every accident. Now we can go to the scene, we can get the layout, we can actually get our diagrams from a real photographic standpoint and be able to utilize that in our accident reconstruction. Even if fault is accepted, let's say it's a rear-end accident. Rear-end accident, everyone presumes that the other person who rear-ended them is going to be at fault. Even those cases are disputed. There's a lot of things that come into play. Why did the defendant hit our car so hard? Were they texting at the time? Is there any evidence out there that they may have been texting or distracted, or what that case may be?
Or impaired.
There may be situations where there's a witness out there who happens to work at Quick Trip, and he may have seen the accident, and we want to talk to those people. Sometimes it's not car accidents. Sometimes it's maybe a fall injury. Maybe they were at the Dollar General store and they fell on some type of product that got spilled on the floor, and or there may be a threshold of the door that may be higher than the rest of the flooring there, and it might be negligent. It might pose a trip hazard. So we want to go get some photographic evidence and see if we can snoop around a little bit and get some additional information on that. And all that goes in, again, is to anticipate the problem that the insurance company is going to argue. And so we're building our case as well.
Okay, so you got your paralegals who do most of this stuff, putting it all together.
Correct.
Okay, they get the file done now. The patient is finished treating. They get their release from the physician. You get all the medical records now.
All the medical records are really ordered up front. Now, sometimes we can get the ones up front, like an emergency room visit or an ambulance ride or some type of radiology. But a lot of times these patients are through an ongoing treatment plan, so we really can't get the records till the end of that care. And we really can't get a final prognosis till the end of that care as well.
Correct. Okay. Now you have all of that now. They're finished treating. They've reached the maximum level of improvement. Now where do we go?
From that point, then we're doing the finalization of the evidence. We're making sure that we have the strongest evidence we can, the strongest evidence on medical, There might be some pre-existing records that we need to go back that we learned along the way that the client forgot to tell us about. As we get those final records, and I look at Dr. Bissland's report and on the history right there in your chart, and says the patient said that they were in an auto accident in 2007. Well, somehow during our intake, maybe they forgot to tell us that, maybe we miscommunicated that, but then we learn that information. So then we have to go back and get those records from that pre-existing condition. That's an example of what's happening towards the end. In theory, we like to have all that stuff done before it gets to that point in finalization, but it never fails. There's something at the end that we need, or it might be a physician who doesn't put down some type of final prognosis, whether it's permanent or what the nature extent of the injury was. It might be handwritten records that we can't read at all, and so we have to try to decipher those and get some additional information on that. But it's always the end that really starts getting a little interesting in the case. When my paralegals get to that point, then the case really, that final piece of the puzzle starts falling into place, and we're trying to figure out what that piece is, what's going to be, the strongest evidence we can get to support that, or put in our client's best light.
Okay, so now we have all the documentation, we have all the records, you have all the history, any previous conditions. Now it's time to negotiate.
One other step. Then we do the evaluation. Before it goes to negotiation, then we sit down and we do a think tank and we say, okay, we're going to make predictions on this case, and we're going to be able to work a different strategy for different insurance companies and different adjusters. There's no cookie cutter process on that. This is where experience comes into play. When we do a case evaluation, we ultimately understand what evidence we have to support the weak link in the case, and then it gets to, well, how are we going to present that? How are we going to do that? Are we going to piecemeal it out? Eventually we're going to get all that information and present it to the insurance company, but we may not want to do it all in one chunk. We might want to go ahead and do it in a couple of chunks, or we might want to go ahead and give them everything at one time. So that evaluation process is key, because we understand how long it's going to take to be able to get through the point of getting it to the insurance company, through negotiations, to the point of a finalization, which is a settlement or the filing of a lawsuit. So the evaluation process, once it goes from Shelby or Stacy, it'll come to myself and Jim Westfall, my senior paralegal. Jim and I have been working together for 25 years. And so we know how to play off each other. And as I was mentioning earlier, it's kind of a good cop, bad cop situation. First thing he's going to do once we get the evaluation, I've got an idea what we think we should get out of the case. It gets forwarded to the insurance company. Then Jim will follow up, generally within 3 to 4 days, to make sure that they received it. Everything we do now is done electronically. The old days of mailing evidence to the insurance companies have long gone by. So we'll scan it. We'll put it into our system. And usually we'll send the evidence to the insurance company on a delayed fax, usually 1 o'clock, 2 o'clock, 3 o'clock in the morning, where we know that fax machine on the receiving end is going to be able to take 100, 200, 300 pages worth of evidence and not tie up the machine in between 8 to 5 regular days. We'll get the confirmation, then we'll follow up 2, 3, 4 days later to make sure the insurance company got it. That's our initial contact at that point. Here's what we got you. What do you guys think? If you have any questions, get back with us. From that point, it literally will take 4 to 6 weeks for them to do an evaluation. There are other law firms that will give insurance companies stuff along the way. That's a procedure that I don't do. I want to keep the insurance company in the dark. It's called the mushroom syndrome. I want to keep them as dark. I do not want them to have any information at all until I'm ready to give them everything I'm ready to sit down and talk about. I can control the evidence that way. That's why a case that comes to us where a person's already talked to the insurance company, of course, their strategy was to take control of the evidence. But if I don't give them anything and I control it, then I'm controlling the evidence, and I can see what I need to give them and how to best argue that. The strongest evidence gets the strongest outcome. So he's following up 2 to 3 days later after he gets the evidence, and at that point there, we'll try to get a timeline. And that timeline will be how long it's going to take for them to take that information, put it into the system. They go page by page, word by word, and it takes them a while to go through that evidence. Then they start developing the questions they need to get some additional information like, well, Lloyd, I see here in 2007 your patient was previously injured. Do you have those records? Well, in fact, I do have those records right here, and I'll go ahead and forward it to them. I won't voluntarily give them that information. They can ask me for it, and I'll get it, but it's not my job to provide those defenses to them. Or I can say I'm not going to give those records, which that's not going to get a settlement anywhere. It'll go to court if we don't provide them documentation that they request.
And we want to avoid court.
We want to avoid court. 75% of the time I can get it settled without even filing a lawsuit. And even the lawsuits I file, half of those will settle within 6 months.
There's another thing that I've heard recently is what used to take 60 to 90 days is now 6 to 9 months.
As far as the overall process?
Yes, sir.
As far as working with the insurance company, or is that from the beginning of the accident till the time it gets settled?
From the time they're released from care till settlement.
It really depends on the case itself. I mean, there are cases that where there's no question of fault, and that there's no other issues, and that we have develop a legal strategy that makes sense to the insurance company. A person that's going to be, as I gave an example before, a person that shows high pain levels probably will have a disruption lifestyle, and we have evidence to prove that. Those cases can usually navigate through a system within 4 to 6 weeks. From the time we get to the insurance company, within 4 to 6 weeks, we can get it settled. Then you have these other competing factors that can slow a case down. What if the patient's on Medicare? And, of course, we have to contact Medicare, and Medicare has to do their research to find out if they paid any accident-related medical that they want to get reimbursed back for. Well, dealing with Medicare can be a slow process. That could take 3 months just waiting on Medicare to provide that information.
Right.
Even if we was to continue negotiating the case, get an offer that my client likes, that I like, and that we feel together we should resolve it with, I can still be held up with these exterior people like Medicaid, Medicare. Now with the introduction of Obamacare, that'll be kind of the same way. It's going to be handled exactly the way Medicare is going to be done. Health insurance has the right to get reimbursed back. And just because now it's mandatory health insurance through the current law, it's being handled just like Medicare. That's the business model they use. It's a bad business model, but that's what they use. And so we are now starting to see some of that, how long it's going to take. And so those things can drag it out. In reality, though, 4 to 6 weeks or 4 to 6 months is still a lot better than 2 to 3 years of a lawsuit.
That is true.
And so it may be a long wait. I always tell my clients a settlement never happens in a timely fashion when they need it. They may really be relying upon the settlement to get them back where they were because they missed a lot of work and they need that income to get caught up on the bills or whatever the case may be. It never happens. It seems like karma dictates the outcome. The more they are desperate for it, the slower the case goes. We do not play the desperation hand with the insurance company because that's a weak hand to play. If they see that my clients are desperate and want to get this resolved quick, they're generally going to be very conservative on their feedback. Their offers are going to be like, well, if I guess they want to settle this thing, then we'll just give them 50 cents on the dollar. And you just don't play that. We walk in with the attitude that we have all the time in the world, and we're off to the courthouse, but talk us out of it. Just talk us out of it. We're here. We're all ears. I've got my case. Here's the case in chief. Here's the evidence that support this. It's consistent with the injuries. And even at that best, you have to still stay on top of insurance companies. They have thousands of files, and so you want to keep that squeaky wheel gets oiled first mentality. And during that 4 to 6 weeks, we don't just let it sit there and wait for them to call us. We're calling them once a week, once every 2 weeks. If they get irritable because we're calling once a week, then we'll back it off to once a 2 weeks. We don't want to get them to where they take our file and stick it on the bottom of the stack because they're so frustrated with us. So there's a strategy on how to work with that adjuster. And the spirit of cooperation is best on that. Despite misconception, attorneys do not get on the phone and scream and holler and make arguments with the insurance adjuster because that's not going to produce a result on the case that's going to be favorable to our clients. So it's generally very professional, very low-key, very Matter of fact, it's methodical. We're going through and itemizing all the concerns that they have, and that's what it's about. We're communicating with the insurance company what their thought process is in case there's something that we need at the last minute to go back and shape up to strengthen the evidence. A typical conversation might be 3-4 weeks into the valuation. Let's say an adjuster at State Farm has the case, and we've presented our strongest argument to them. Now we're waiting for them to finish their valuation. As I mentioned before, they go page by page, word by word. They also input it into a computer. Everyone utilizes computer models now to help assist their evaluation on that. What is the jurisdictional value on the case? For example, cases in Tulsa versus cases in Oklahoma City are valued differently because we have different demographics. And you can almost make some predictions based on what county it's in on whether that's going to be a more conservative offer or a more liberal offer, a lesser offer or a higher offer, just based on the jury tank, the jury pool that they're dealing with. Tulsa is very conservative. It takes a lot of persuasion to get through a Tulsa jury in the court. Something else to think about in that negotiation process is, as I just mentioned, the jurisdictional value. But the insurance companies know this as well. I mean, they have a fine science of this stuff. They have variables that they input into this thing that is well beyond anything that any plaintiff law firm is going to ever spend that kind of money on for those kind of tools. We're talking about, for example, the Colossus computer system that is a nationwide network that Allstate uses. It's a claim evaluation tool. The implementation and the maintaining cost for that and the training for adjusters to use that are several $1 million just for that claim evaluation software. We use more of a conventional system. We're going to use based on our experience. We're going to base on what we know a jury is conservative. Not to get political here, but let's say that in Tulsa, 9 out of 10 times you're going to draw a very Republican-based type jury. You're going to have maybe a couple of people that consider themselves to be tea baggers, Tea Party constituents, and we are going to be shaping our case to address those concerns, which the baseline for that mindset is accountability. And that's how we approach it with the insurance companies in Tulsa. It's all about accountability of what their insured caused my client. We want to hold them accountable for it. And that's why we use that line item approach and say, here's, $300 for mileage, 42 cents a mile round trip going to the doctor. My client didn't need that expense. Your insured caused my client to incur this expense. That's an expense that we're going to be seeking from your insured, from the defendant, to pay on this, for a simple example. And so we make those arguments not as a whole as a value, but in the individual components of damages. Pain and suffering. Pain and suffering is a damage. As I mentioned before, pain and suffering is not ouch, I hurt, but during our evaluation process, our workup process, we have evidence we have the client provide, or we can build up with the client's assistance on that as to how do we prove pain and suffering. It must be proven. Folks that are working with insurance companies that don't use law firms think pain and suffering is some magical figure. Used to hear that, well, you take your medical bills and multiply it by 2 or 3 or 4, and that's how you come up with pain and suffering. Well, that's ridiculous. It's never been that way. If I scratch my hand and a doctor puts a Band-Aid on it and he charges me $5,000 to put a Band-Aid on it, do you really think the insurance company is going to give me $15,000 worth of pain and suffering for that Band-Aid? So you can see the process is based on the nature and extent of the injury. Pain and suffering follows that basic premise. The more you're injured, the more pain and suffering you'll have. That's conventional wisdom. We don't need a multi-million-dollar claim evaluation software to be able to figure that in. But what we do have to have is evidence to show that. That's where Jim Westfall and myself, when we get into the negotiation stage, we're giving this information along the way. Sometimes we give it to them all at once. Sometimes we piecemeal it out. It's like playing Texas Hold'em. And we've got that river card out there on the table, and we know that river card, they're holding that card, and we're going to be playing off that card right there. So we know that we want to sometimes bluff them And sometimes we want to just we bluff them, or you give them a little bit of information at a time. It's just a strategy that we use, and it's successful, and it settles between 70 and 75% of all the cases that come through my door. And I'm not cherry picking. When people come to my office, they can be somebody that has a minor injury, or it could be a catastrophic injury. And that's just the way my system, my business model is designed to do, is to work it no matter what the level of injury is or how severe the injuries are. They're all being worked the same. The only thing that's different is the amount of evidence it takes to require to prove those cases. So that's why the evaluation process is very important, to filter that into how are we going to deal specifically with this one case, with this one adjuster at this one insurance company, because it's different. 25 adjusters at State Farm Claim Office. I'll tell you, all 25 of them have different approaches and different biases and different discriminatory outlooks on evidence. And so we have to know those people, have to know who our opponents are. Just like sports, when Oklahoma City Thunder plays, the Spurs, they know what that shot record is. They know what certain statistics are in players. They know from a statistical standpoint, one-on-one on any particular player, the potential outcome that's going to happen. Well, that's what we have to do. We have to understand who our adversary is in this thing, and that evaluation process and the negotiation process is all important at that stage. It's not a cookie cutter. Now, the insurance companies use a cookie-cutter approach. Low-impact accident, therefore you're not hurt. Pre-existing conditions, therefore half your medical probably is to something that's not even related to this accident. And they have this playbook, and it's very predictable. And there's literally hundreds of those generic cookie-cutter defenses. So when we're in negotiations at that point right there, we get confronted with this stuff because a lot of times they've never seen this evidence. This is the first time they've seen the evidence, because we present it to them in one big bulk where we can control it. But I know they're going to ask that question. I know they're going to bring up the amount of damage to the vehicle. I know they're going to be talking about that my client has a previous history of accidents. And by having the answers already for them, and they're having to react to it, not me, they're having to react to it,
Right.
Then I can control the outcome. And that's part of that process.
Well, you said 75% of the claims that you actually are able to settle, you do end up in court, though.
Oh, quite a bit. I think if you go on oscn.net and you type in Lloyd K. Benedict under search docket, you're going to see a lot of lawsuits filed in my career. Lawsuits happen for two reasons. One, because the case is not real strong, and we're going to take it to another level to show them that we still have some sincerity in pursuing the case. The other reasons why they happen is because the insurance company is taking a defensive standpoint based on something that might be a legitimate reason, or it might just be a complete stupid reason. And I can give you examples of cases that have had that happen, and it's frustrating. You might have a new adjuster. He's on the job for 6 months, and we don't really have any history on this guy, but we know he's a noob, and we know that he's going to be just very playbookish on his responses. I might have a client that has a back surgery caused by a high-impact accident. My clients miss 6, 8, 10 weeks worth of work due to this. Large scar on their back from a disectomy of some sort. And then the insurance company says, well, I see here that after the accident, your client said he gave a recorded statement and said he wasn't hurt. So we're just not going to pay anything. You might want to go to court and convince them otherwise. Well, as we both know, as I discussed earlier, what happens within 24, 48 hours, 36 hours after an accident, the body is going to just not follow the insurance company playbook of I'm not hurt and therefore I'll never be hurt. We all know that those injuries are going to manifest themselves a lot differently and differently in people. Not just the same people have the same manifestation of symptoms.
Exactly.
It might be 2 weeks, might be 4 weeks. I all the time have a client come in with a neck injury 2-3 days after the accident. But within 2 weeks, I'm going to have Dr. Bissland take a look at my low back now because it's just something's not right with it. And so things start developing. I mean, the physiology of the body is you might have a knee injury on your left knee and for 1 month, and you shift your weight over to the right, and now your right knee's starting to wear out. And so things happen, and that's why people should never give a recorded statement to an insurance company. It's a defensive tool.
They want them as quick as possible.
They want them as quick as possible because they want to lock in the evidence, and if anything changes, then they have justification as to why they're going to do a certain outcome on the case.
Now, when you are in court, something I had a patient ask the other day that they didn't understand. When you file the suit, you're actually suing the defendant, the driver of the car that hit your client.
Right.
You're not suing the insurance company per se.
No, you cannot sue the other person's insurance company. That's prejudicial to the case. In fact, in a lawsuit, you can't even use the word insurance company. Otherwise, you'll have a mistrial.
So, in other words, 85-year-old lady rear ends somebody and causes $50,000 worth of surgery. The defense is going to sit this little old lady who has nothing but Social Security, and how do you get around that then to let the jury know that it's not her personally that's going to pay these damages, but her insurance?
You have to be careful on that, because once you go into that zone right there, there are ways. Now, if they voluntarily say it, it's not a mistrial. It's only if the plaintiff brings it up.
Right.
So there are just different ways, depending on who it is, to be able to bring up the famous insurance word into court. One of the techniques might be is to maybe talk about the car damage and to get the defendant on. Well, it's going to happen in a deposition. There's not going to be any ambush testimony at a trial. It's all laid out beforehand before it even gets up to the trial. So really you want to get that out in the deposition and not at trial, because at trial, if they bring it up, their own attorney at that point there can have the jury swapped out.
Okay.
They really want to keep that error that little old lady over there is paying for it out of her little, yeah, that's right. That's how they want to do it.
Exactly.
And that's a little unfair, but that's the way the system's set up.
Exactly. Let's take a break and we'll be right back.
Are you in pain? Then meet the doctor. Neck pain, headaches? Meet the doctor. Low back and leg pain? Meet the doctor. Arm, shoulder, and hand pain? Carpal tunnel syndrome? Meet the doctor. Injured in an auto accident? Meet Dr. James Bissland at Bissland Chiropractic, where you can get your first visit free this month. Call Bissland Chiropractic at 838-4252. Bissland Chiropractic.
Where were you when the lights went out? Who did you call and when you gave them a shout? Did they pick up the phone? Did you get a machine or some front office drone? You know what I mean. You want to talk to somebody who knows what they're talking about. So call Marie now. Electricians with a mission will get you connected. We're Marie Electric.
Hi, this is Larry Murray with Murray Electric. We appreciate your business, and we don't take you for granted. While nobody likes to have electrical problems, we want you to know that we will be here for you when you do need an electrician. And remember, you don't get phone shuffle when you call Murray Electric, because we have a real live electrician that answers the telephone. Remember, if you're in a hurry, call Murray, 918-835-9605. 918-835-9605.
We'll get you connected. We're Murray Electric.
An accident can turn your life upside down. Immediately, you may face problems like who will treat your injuries? How will your car get fixed? What are you going to drive in the meantime? You need solutions now. At Benedict Law Office, the care you deserve can begin at your own home. No office visit is necessary, and you pay no fee if there's no recovery.
At Benedict Law Office, there are no problems, only solutions.
Call Benedict Law Office for your free consultation today.
All right, welcome back to Health and Information. And we're visiting with personal injury attorney Lloyd Benedict. And we've been discussing the path of a personal injury claim and how it's handled all the way through the process from the intake through the negotiations. Now we're going to talk about the final settlement now. All of it's been done. All the discussions with the insurance companies are now done. So, Lloyd, tell us how you finally close it and get it finished.
The final closing of the file is going to happen in a few different ways. And as you know, we've talked about the investigation We've talked about the evaluation. We go into the negotiation, or we go into litigation. So it's the 4 shuns. And with the closing of a file, it'll either happen through being able to compromise a settlement. That is where the insurance company and I have got engaged in the exchanging of the evidence back and forth. Somewhere along the way, the dollar figures come up. And that's going to be based on something. There's going to be some rationale as to why the dollar figure is a certain way. It's just not, you just don't pick a figure out of the air. And so, as I mentioned before, between 70 and 75% of the time, there's a little 5% margin there because those cases can get complicated even after we get into negotiations. That can happen through a settlement. And what is a good settlement? A good settlement is where my clients do not think it was fair and the insurance companies think they overpaid too much. So about every that situation is going to be within that 75% of the time. 4 to 6 weeks is the average time on that. If we get to the negotiation, the clients are informed as to what the figures are, how they break down, ultimately what they will net in their pocket from the settlement. There'll be some paperwork involved. The insurance company wants an insurance company release, a release of all claims, and that is, since technically a settlement is a contract, in other words, somebody's doing something and the other party's doing something, well, one person is giving money, the other person's giving up their right to sue or pursue the lawsuit against the defendant. So that's why it's a contract. Well, how's that contract proven? Through a piece of paper called a release of all claims. And a release of all claims, they're boilerplate language. The insurance company do not type them up to suit any particular settlement. They put in the dates, they put the name of the parties, the date of accident, and the facts, and of course the dollar amounts. Once that's signed, the insurance company at that point there will be issuing some type of settlement, and we already know the dollars of that settlement, who's getting what at that point there. The client already knows how much they're putting in their pocket at that point. Our attorney fee comes out of the settlement. It's 33% of the total recovery or less. My fee will actually reduce its fee down in circumstances where, I'll give an example of that. If, let's say the settlement was for $1, but let's say the medical bill was 90 cents. For whatever reason, the medical bills were just high because of the circumstances of the injury. The insurance company wanted to fight it. The insurance company didn't want to go to court, so we're settling on the case. Well, if I took my 33% fee, the doctor bills would not even get paid, and the client would put nothing in their pocket. Well, there's no incentive for a settlement at that point. So my 33% fee would be reduced down to like a nickel. My clients would get a nickel, and the 90-cent medical bill would get paid. So you can see that's a 33% fee reduced down to a nickel. Realistically, things happen differently, and we try to get the client a little bit more money out of the circumstances, but we take that on a case-by-case basis.
So there's no normal.
There's no normal when it comes to that. There are law firms out there that get paid right off the top, and they're pretty proud of themselves, but they have expensive TV campaigns to finance, so you can understand why they do that.
The Rolls-Royce payments do.
That's right, the Rolls-Royce. And so, but the settlement is proven with a release of claims. Then I have a settlement summary that gives the clients an accounting of the figures. We have the total figure. Then we have everything that's being deducted. We have the paying of the medical bills coming out of that. We have the reimbursing of any health insurances that are coming out of that. We have the attorney fee coming out of that. And, of course, there might be some case expenses for us having to purchase, like medical records or an accident report, or in the event of litigation, the expenses could be a lot higher. Obviously, there's filing fees and depositions cost and court cost and those sort of things. Settlements don't have those larger expenses. Lawsuits will have some expenses, but that's discussed with the client before we get to that point. So we can finalize a settlement with just some paperwork, and usually that release will come when the insurance check is mailed at the same time, or the insurance companies want to have that release executed and faxed back to them first before they mail a check. Once the settlement check gets here, or settlement checks, it might be multiple checks, they are deposited into my trust account, and that usually takes about 3 or 4 days for it to clear the account. Once it's cleared the account, then I issue checks from my trust account, issue a check to my client, to myself, and to all their medical debt that's being paid from the settlement. And at that point right there, that settlement's concluded. If a case can't resolve that way, it has to maybe go to a different level. That level would be litigation. And litigation is a time-consuming process, but sometimes it is a necessary process. I'm a lawyer, and that's what I do for a living. I file lawsuits. A law firm, when you hire a law firm, you want to make sure that law firm files lawsuits. There are law firms that do not file lawsuits. For whatever reason, that's their business model, but that would not be the law firm I would hire. I would want to hire a law firm that can resolve the case from the beginning all the way to a jury trial if need be. I do bring in associate counsel sometime if my litigation, there's only so much time. I'm by myself. I don't have other junior lawyers here. So I kind of pick and choose what lawsuits I want to engage in. We can be talking about 1,000 hours in a lawsuit, 2 to 3 years worth of work. And so I've got to pick and choose which one. And I'll tell the clients up front. In fact, during the legal strategy, I'll know at that point right there whether that's a case that should be litigated ultimately. Now, sometimes filing a lawsuit doesn't mean going to court. In fact, I'd say half the time they'll settle within 6 months if there's some strong evidence there, as just like we evaluated it and negotiated with the insurance company. Now we're talking to somebody else. Now we have a defense attorney that comes into the picture, and I'm having to renegotiate and compromise with that attorney. He, on the other hand, gets paid by the hour. He's paid whatever the hourly rate is. It's between $95 and $120 what the insurance company pay these guys. And so they're wanting to get some money out of it. They'll want to get some paperwork. They'll want to get interrogatories or requests for production of documents or requests for admissions, or then they'll get into ordering all the medical records again. Even though I already given it to them, now they want to order all the medical records. Plus they want to get 10 years of previous records. Depositions. They want to take a deposition of my client. They want to take a deposition of all the doctors my client saw, and they'll want to send my client out to their doctor, which is usually a bought and paid for medical opinion that the insurance company pays for. So this whole time, these hours are clocking up and the bills are getting sent from the defense attorney to the insurance company to get paid, and he's making money off of it. That's why it takes long. But that's part of the process, and that's just the way it is. Not that they're doing anything wrong. If I was a defense attorney, I'd want to investigate the case and understand it and get all the information as well. But that's why it can take long, is because of that reason right there. I've learned a long time ago that if I know the defense attorney, and we both know that ultimately there could be a trial on this, we're going to want to try to compromise these things, and usually within 6 months, I can get the case settled. And most times more than it was at the insurance company level negotiating with the adjuster. The problem is, even though I got more money, now I have more expenses.
Exactly.
And so it kind of balances out, comes out about the same. Sometimes comes out a lot better. But predictably, there was no benefit to my client to file suit. I have a lot of clients say, well, just file suit. Well, one, I'll do that, but all you're going to do is give me more money. You're not going to get any more money in your pocket on a statistic basis. But I have no problem doing that if that's what you want me to do. There are some things that come out during litigation that can actually hurt the case. Now we're under oath. Now we're in a deposition. Now the defense attorney has hired private investigators, following my clients with video cameras. Getting into medical records that maybe my clients completely forgot about. My client may be mowing the lawn when they testified they couldn't, but you know what? No one else is going to mow the lawn, and they're going to get a fine by the city, and they hurt by doing it. But that video camera doesn't show that. The private investigator that takes those pictures, he's just showing the activity. He doesn't show what my client paid for it by being stoved up for the next 2 days after they mow the lawn. So, but those are things that hurt the case, and all of a sudden now we're losing value. Now we're losing control of the case. Now it's being turned back over to the insurance company or the defense attorney. But that's the next step, is the litigation process. But despite that, half of those that I get involved in will settle. I would say of all the lawsuits I've filed, and there have been hundreds, of all the lawsuits I've filed, I would say the vast majority of them have settled. Very darn few go to a jury trial.
Okay, we got one more topic I want to bring up, because this is something that people don't understand. And recently you and I had my patient, your client, that this pertain to, and that is the no pay, no play.
Yes.
You want to explain that and how it works? Because we're one of very few states that actually has that rule.
Yeah, no pay, no play is a law that was put into effect on November 1st, 2013. That simply put means that if you're driving a car that you had no insurance on and you're a victim of an accident, then you're limited on the amount of damages that you can claim. The only damages that you would be entitled to recover would be your medical bills, or at least reasonable medical bills, and your lost wages, out-of-pocket expenses. No pain, no suffering, no mental anguish, no permanency, no permanent impairment. And so it's seems to be penalizing the people that had to make a tough decision on their budget, whether to pay rent or to pay for, car insurance. But that's what's going on.
Now, how about the legal bills?
Do not pay the legal bills.
They do not pay those.
Yeah.
Okay.
Yeah.
That was a question that came up, and that one I didn't know the answer to.
In the state of Oklahoma, the defendant in a personal injury action is not liable for the cost of it took for you to hire an attorney. The expenses, some of the expenses, but the statutory rate, the expenses, it may cost me $3,000 to take a doctor's deposition on a video deposition, but I can only get reimbursed back $75 by statute.
Wow.
So ultimately, that cost is passed on to my clients. That comes out of the win, the court award, or the settlement if the case settles somewhere along the way during the litigation process.
Okay. Well, Lloyd, I appreciate your time. I know you're busy, and we thank you for taking the time to go through all of this. And I'm sure that there is some information that you provided that people didn't know before. So we do appreciate you taking the time to do that. And we thank you all for watching, paying attention. If you have any questions from a medical standpoint, on the screen you'll see my contact information. And also, we have put Lloyd's information on the screen for you as well. If you have any questions legally, before you talk to an insurance company, at least call and talk to an attorney first. I'm Dr. James Bissland. Thank you for joining us. We'll see you next month.